Hi, Mac Pierre-Louis here, attorney at law and mediator in Houston, Texas. You can reach me at my website, macpierrelouis.com. Welcome back to the next video in the series on the intersection of immigration and family law. Today, we are talking about divorce.
Hi, my name is Shelle Simon. I'm the managing attorney at the law office of Shelle Simon, based in Houston, Texas. You can find me at www.shellesimonlaw.com. Immigration status may sometimes become a factor when determining custody, support, or divorce. Mac, do you have any examples that you've seen in family law?
Yes, so one of the most common examples is when a person comes to me and they're basically asking, hey, I don't have immigration papers, so what should I expect in divorce court? Most of the time, it doesn't really matter. Why? Because most family courts don't investigate your immigration status. They're more concerned about protecting children and helping you go your separate ways from your spouse. So typically, your immigration status does not come into question. However, there might be some concerns where one spouse tells the court that unless they do something to impact your custody or your visitation right, you might be a flight risk with a child because you don't have immigration papers. So that's when it kind of becomes an issue, and you need to talk to a lawyer on how best to protect against the allegation or accusation that you might be taking little Johnny out of the country to fly them to a foreign country, never to return. So that's typically when immigration issues comes up in family courts. But Shelle, what happens if you have a new immigration spouse married to a U.S. citizen spouse, but they want a divorce soon after, within the first 2 years of their marriage?
Well, that could cause a problem, Mac. You need to be married for at least 2 years, and if you don't, you may have some problems getting your permanent green card. You would need to get properly advised by an immigration attorney, depending on your situation. If you're unable to stay in your marriage for domestic violence reasons, you may be able to self-petition through VAWA, the Violence Against Women's Act.
So if the spouses stay married to each other for the required 2 years, how does the foreign spouse get their permanent green card?
A conditional permanent residence is given after marriage to the foreign spouse and a U.S. citizen. After the 2 years, you would then trade in the conditional permanent residence for your green card. This is done by filing a petition to remove the conditions on residence. Both the U.S. citizen and the foreign national spouse would sign the form and return to USCIS. If a divorce or annulment happens before the 2 years have passed, signing the form will be impossible. Divorce can have serious consequences for the foreign spouse who has not yet been married to their U.S. citizen spouse for the required 2 years. If they divorce before the 2 years, the foreign spouse could possibly face deportation.
Yeah, that's a big deal. So thanks for the insight, Shelle. So this wraps up another video on the intersection of immigration and family law. Again, this is Mac Pierre-Louis, attorney at law and mediator in Houston, Texas. And
I'm Shelle Simon. You can also find me at www.shellesimonlaw.com.
And mine is macpierrelouis.com. Thanks so much.
Bye-bye.